Hello and welcome everyone to the Office of Technology Commercialization's February webinar. A few housekeeping items to remind you to please keep your mics muted as we are doing closed captioning and recording so that we can share this with you later. I'd like to introduce Matt Upton. He's our Senior Associate Director for Intellectual Property Development. He will be talking about the innovation disclosure process from beginning all the way through the process. And if you have questions, please put those in chat. You can put those in chat to me directly or to everyone. Welcome, Matt.
Thank you, Jackie. And thanks everyone for showing up on a dreary Thursday. So as Jackie mentioned, what we're looking at today is a deep dive into the innovation disclosure process. So I know, sometimes it can appear like a black box from the outside that a disclosure comes in and then some things happen and what's timing, what are we looking at in the overall process? So what I wanted to share today, kind of our roadmap of where we're going, is essentially the disclosure process. When and how to report. I will almost every talk kind of describe that. And then what to expect from the process. So what happens behind the scenes, what meetings are held, what are we looking at as an OTC office to make our decisions, kind of the types of intellectual property at the University of Kentucky that we file on. And then a little bit about the patenting process. The majority of disclosures that we get to our office are related to patentable technology. And I just wanted to shed a little bit of light on that patenting process itself, how long it typically takes, and discuss it a little bit. So if we're looking at the kind of the lifespan of academic innovation, we're kind of going to be talking up to that protection part. So the innovation itself, the disclosure that comes into our office, how we evaluate that disclosure, and then deciding on what type of protection. Now, marketing is seen at the end, and that happens a lot, but don't think of it as that marketing waits till after the patent is issued, right? Once we determine we're going to protect that intellectual property, that marketing begins immediately. And we make all of those other decisions you see on there: license to spin off our industry, and then product development, commercialization. So we don't wait for the issuance of the patent, those immediately start. So with this innovation, right, it all starts with a discovery, right? So it doesn't happen in our office, it happens in the labs of our researchers around campus. So now that you've done the work and made a great research discovery, now what, right? That's the question. I've done this thing in my lab, now what do I need to do? So specifically, you need to file an invention report, right? Report a discovery or invention. The reason we want both is we can help with a lot of things. It may be a biological material that you can sell that can't be patented, but we can assist in licensing that technology. So after that discovery or invention is developed in the lab, when should you disclose it, right? Specifically, you need to let OTC know before you publish or present. This is especially true in anything you believe may be patentable. The reason for that is that any public disclosure or presentation of that technology begins our clock running in the United States. It gives us a 12-month window in which to file, and it also precludes our filing in any country outside of the United States. So already we've limited the scope of what that patent protection can be if it is published before we're able to get something into the patent office. But what should you tell us about, right? You need to tell us about anything that may be a great research development, a valuable research tool, or even just a cool idea, right? It doesn't have to be earth-shattering. It doesn't have to be something that, if there's any question at all about whether or not it should be disclosed, it needs to be disclosed. Now, that before you publish or present applies to patented technologies. We'll talk a little bit about copyrights and how that's different a little later. So how do you submit an invention? Well, it's pretty simple. You follow that link. We have several locations on our website that our innovators can follow, and it takes you to our online disclosure form. For the most part, our online disclosure form is working fine. There's always a couple of hiccups because we're relying on two databases communicating with one another. And sometimes that can present issues if data is in there twice or it's corrupt in one of those sources. But typically we're able to straighten that out and allow our innovators to use that online tool. Now, we do ask some questions different from what we've typically asked in the past. So what type of information do you need before you begin to fill this out? So some key ones that we need to have are simply the innovator information, right? So we need both work and home addresses. That seems a little invasive potentially. However, if you would ever want to get paid on your invention or innovation, we need your home address. Anytime distributions are made, we cannot distribute any money to our innovators to a UK address. So we need that home address. And if you move, it needs to be updated with our office, or else we cannot get you your check. In addition, we need the link blue email address, unless, of course, the innovators from another institution, which can happen quite a bit in collaborations. And when I say that link blue email address, I mean both the letters and number email address in there, because that is how things are saved in our database. We also need the employee ID number. The reason we've added this is that, as many of you may be aware, there's a new initiative that has started at the university called Scholars at UK. And the way that that database is kind of compiled, kind of runs off of the employee ID numbers. So we have to collect that as well, put it into our database so that that information can be shared with Scholars at UK. So if a new, if one of your innovations is we filed for a patent and it's become public through publication or issuance, that can appear on that Scholars at UK page. In addition, we need any funding information. So that includes funding not only from the federal government but also any sponsored research agreements or similar type of agreements where the money is coming in to fund that research from an outside source. And with that, we need the actual numbers that go with that. The reason is there's a lot of compliance that goes with federal funding. And our office, as well as filing patent applications and copyrights, we're also in charge of maintaining compliance with the federal government. So anytime that there is a disclosure, we have to notify the federal government that that has been done. If we decide to file a patent application, we have to notify the federal government. If we convert a provisional application to a non-provisional application, we have to notify the government. When it issues, we have to notify the government. If we sign a license agreement associated with that technology, we have to let the government know. Whenever a first sale of any product licensed under that technology is sold, we have to let them know. We have to let them know how much money comes in royalties. So there's a lot of times that we have to ping the federal government and keep them updated on technologies developed through federal funds. We also need a complete description of the invention or innovation, right? But the system allows for attachment of documents. So if you're working on a manuscript for a journal or something similar, maybe you're getting PowerPoint slides ready for a presentation, we would just ask that you send those along and you can attach them directly in the application, and we can take a look at that. So that way you don't have to duplicate or cut and paste or anything like that. In addition, we need to know about upcoming publication dates. So as I mentioned before, one of the things we have to maintain is kind of that patent filing first kind of mentality. So what our office needs to know is, are you planning on publishing this? Is there a date set? Is there a deadline we need to get this technology into the patent office? So you've gone through that disclosure form, you've submitted it. It's come into our office. One of the things you'll receive is an email letting you know that we received it and assigning it a number. But internally, what happens is we take that innovation, we review it initially and assign it a technology class. So if your innovation relates to energy production or CO2 capture and energy, that is noted in our system. If it comes in related to protocols related to social work, that goes into our database as social innovation, social work. So we assign a class to it. We also review the type of intellectual property, and we'll get into the various types of intellectual property that we have kind of in rank order on the next slide. And then an OTC fellow is assigned to conduct an initial review of the innovation. So that initial review, well, let me back up and first say our OTC fellows are student workers that we have here in OTC that are made up of either individuals with a science background that are currently in law school that have a desire to be a patent attorney or know more about patent law, or typically graduate students in some areas that we need assistance with. So a lot of our applications come from pharma. So we always like to have someone associated with pharma on our fellows team. So they're familiar at least with the scientific principles behind a lot of our inventions that come in, or at least aren't scared away by the big words they have to say in meetings with our innovators. So a fellow is assigned and they conduct an initial review of the innovation. That initial review consists of, one, making sure that our office understands the technology. So they'll read over the disclosure and make sure that they have at least comprehended the invention somewhat and tried to find that novel feature within the invention itself. Once they've done that, then we will conduct a prior art search related to those novel features of the innovation. And when I say prior art, that's, a term that we use in, as a patent attorneys or in the patent field, that simply means, and it's a very broad term, anything that's ever been written prior to when we do the search. So that's how the USPTO views prior art, that they can use against your innovation to say it is not novel, is if it has been written down. And it doesn't have to be in paper form, it can be electronic form. So that means there is a lot of prior art. It doesn't have to be in English. It could be a Japanese patent application that's been machine translated. It could be a Japanese application that hasn't been translated at all. They can still use that against your innovation. And it doesn't have to be just patents either. It is also journal articles and things of that nature. It could be websites. So just anything. So what our fellows do is we have a service that we subscribe to that allows us to do a little bit more in-depth patent searching than you can do on Google Patents or any other free resources on the internet. And we also conduct a search of what we refer to as non-patent literature, so journal articles and things like that, to try to find art that is closed that an examiner might use to base a rejection on. So after that occurs, and even at this kind of the same time before that meeting is held, the innovation is discussed internally and assigned a commercialization manager. So the very first thing, as I mentioned, that was done, it's assigned a technology class. And the way our commercialization managers are kind of split is each of them handles a different technology class, essentially. And based on that technology class, the innovations are divided among the commercialization managers, and they start taking a look at it from a marketing standpoint. And then once that fellow's initial review is done, we have an innovator meeting. So we will send out invites not only to the innovators, also to the commercialization manager over that technology, as well as an IPC representative. So the IPC is the Intellectual Property Committee that actually makes the decisions on whether or not this is UK technology, whether UK owns it, and kind of decides, are we going to back this and move forward with an application? So that's kind of the process up until that meeting. But one of the things we look at is what type of intellectual property does this innovation fall under? So traditionally, when people think about intellectual property, there are 4 different types that we have. If you just Google IP, but mainly our focus at the OTC office is the first 2. So first is a patent, which provides us with the right to exclude others from making, using, or selling the claimed invention for a limited term. That term is 20 years, not 20 years from the date the patent issues, but essentially 20 years from the date of filing. And we'll find out why that's important a little bit later when we look at timelines of the patenting process. So this is probably the number 1 form of intellectual property we have that comes in from our disclosures. But it is starting to be rivaled by the next one down, which is a copyright. So with a copyright, it essentially, again, protects the copying of original works and that are in a fixed expression, right? So fixed expression can be on paper, it could be electronic. It's not limited in that way, but it lasts for the life of the author plus 70 years. So a very long time, not like the 20-year term that you get with a patent. And with both of these patents and copyrights, it's important to remember that the general idea behind the inventions are not, or innovations are not protectable, right? It is that actual embodiment of the innovation that becomes protectable. So with a patent, if an innovator has an idea of using a certain class of drugs to treat a disease target, that idea itself is not patentable. However, if experiments are run that those type of therapeutics can be used to treat a target disease, that is what's patented. Similarly, with the copyright, the ideas behind the copyright are not protectable, just the way in which those ideas are expressed in that fixed expression. So there's also 2 other types of intellectual property that people will commonly see, but they're not that common at the University of Kentucky. So the first is trademarks. Everyone's familiar with trademarks pretty much on a daily basis, from billboards to grocery stores to malls, whatever it may be. And a good example is the Nike swoosh. So essentially, trademarks ID unique sources of goods or services, and it's good for as long as the registration is maintained. So if you're at a company and that company has a trademark, that trademark could last for hundreds of years if that company is still making that product, over that several hundred years. So with that, it is potentially the longest lasting form of intellectual property. However, the reason we don't use these a lot at the OTC office is because it identifies a unique source of goods or services. The University of Kentucky is not in the business of selling goods or services for the most part. when it comes to our innovations, right? That is typically licensed out to either a startup or an industry partner, and they actually become the source of that good. There are some exceptions when the university has a program they're looking to get buy-in from industry. Maybe we trademark that, but typically these trademarks would be the responsibility of our licensees of the technology. And then the last one is trade secret, which can be protected as long as the secret is held. So if the number of people that know about it is limited, it can go on forever, but it doesn't have the same type of protections as the other types of intellectual property. And when I say that is a patent, if you have a patent that claims a certain thing, you can exclude others from doing that. A trade secret does not give you the right to exclude others if they start copying your trade secret. The reason is it's now become public if someone else can do it. So typically the only time trade secrets are used is typically in processes that you don't believe someone else could copy readily or within the lifetime of a patent. So you don't have to let others know how to do the process as you would with a patent to allow them to design around, and you can keep that in-house. The reason we don't use them at the University of Kentucky is we're an academic institution, and part of the desire of our innovators is to publish in journals, which would immediately destroy any type of trade secret. Typically the only time you can even try to sue or go after someone for using your trade secret is if they were a previous employee, went to a competitor and took those secrets with them, and that new company started to practice what was your trade secret. So it's more of a theft type lawsuit rather than an infringement type lawsuit. So those are the type of IPs, and I mentioned that we have our initial innovator meetings. So as I mentioned, we conduct a prior art search of both scholarly articles and patent literature. Again, using that subscription service we have to a robust patent searching tool. We also do a market analysis to identify potential industry partners. So what we typically do is we run our patent search. We take a look at who the big players are in this area. So what companies are filing patents related to this technology that's been disclosed? And we do a little research based off of that to find what appears to be matches. So if you have developed a potential therapeutic for a particular disease, we may look and see, who's filing patents for therapeutics on this type of disease, or who is attempting to develop drugs in this area, and they would go on the list and may get shown to the innovator because this is obviously a company that is interested in that particular disease state. In addition, in that innovator meeting, we have discussions with IPD to develop IP strategy for the innovation and introduce the commercialization manager. So with any IP, sometimes it isn't as simple as, oh, the invention came in, we want to go with a patent, so we'll file here. Sometimes it's discussion of maybe the invention is just a little early to file on. Maybe there is a funding issue that it would be better suited to delay a filing to make sure funding can come in before the next step. Because once we file our first provisional application, we have a 12-month window to decide whether or not to convert. So we want to make sure that if more steps need to be done to get a full patent application together, that those steps can be completed within that 12-month window. And as I mentioned, it's also an opportunity to introduce the commercialization manager that will be handling that technology. And, typically questions are asked on, what's the goal if the innovators know of any potential partners that are out there, and just finding out more about the technology to know how to market that technology to potential partners. And the reason all of this is important, in the protection of University of Kentucky IP is important, is that companies typically will not pursue an innovation unless it is protected, right? Because companies want exclusive access. They want something that gives them a advantage over their competitors. And the only way they can get that a lot of times is through intellectual property and that exclusivity that comes along with it, right? That ability to exclude others from making, using, or selling. So looking at this, potential partners and the IP itself, we kind of look at this cost benefit considerations. So from the cost side, pursuing a patent is expensive, right? A typical US utility application may cost upwards of $20,000 to draft and file, and another $20,000 for prosecution plus maintenance fees. So to draft and file just initially to get the application into the patent office. And then typically what happens, 99% of the time, the USPTO is going to inform us that we don't have a patent. There's something too close. And we will typically get with the innovators, our counsel will take a look at it, and we'll discuss how best to overcome those rejections. So we have to pay for that. Typically, I think right now the average is 2.7 to 2.8 office actions. And only 2 of those come without even having to pay an additional fee. So it could even run above this estimate. And then even after a patent is issued, we have maintenance fees to keep it alive, because the federal government doesn't really like monopolies. It wants to make sure you're using that innovation. And if you're not using it, then it ramps the cost up on you to maintain that monopoly you're granted with the issuance of a patent. But that's just the US. So around $40,000 to $50,000 for an application in the United States. And then you have individual foreign applications. We typically don't file foreign applications. We have in some instances, but our patent budget typically won't allow it. But they cost an additional $5,000 to $15,000 to file, plus substantial prosecution and annuity fees. So unlike the United States that has this maintenance fee structure that kicks in once a patent is issued, so our maintenance fees are due at 3.5, 7.5, and 11.5 years after a patent is issued. But in other countries, they have an annual fee that you have to pay, and it ramps up just like our maintenance fees do in the US. So they may start out at $1,000 a year, and by the end of the patent's life, maybe upwards of $5,000 a year just to maintain that patent. And prosecution is significantly more, because not only are we dealing with the law firms we have to deal with under state law here in the United States, they have to contact foreign counsel in whatever country we're filing, and we also have to pay the bills for them as well. So a typical patent portfolio with foreign filings could quickly reach over $250,000. So if we decide to file in 4 countries, it wouldn't be surprising to be up in that range. And that would represent essentially, about 1/4 of our annual patent budget just to do that. So that's some of the cost considerations. So in looking at the kind of the return aspect of this, what we're looking at is what's the commercial potential, excuse me, of the technology. So is there a large market? How much money do we think we can recoup? Are there products from the technology, right? Is this a process, or is this a thing that could be sold? We also look at who are the customers, who are the stakeholders. So before we file any patent, what we like to do is establish that if we file this patent, who do we think potential infringers would be? because those infringers would be the customer. So with that, if we're talking a medical procedure, that would rank lower on the scale because your potential customers would be actual physicians. And if the goal is to get this procedure in practice, that isn't where you want it to be, right? You want it to be used by doctors, but you don't want to hold up doctors from being able to, perform the procedures you have developed. We would prefer that if that procedure used a device, to get a patent on the device, because we'd rather go after the manufacturers and require a license of them. So that way, anyone buying the device could use it freely after that fact. And we typically like to have the patents directed to whoever has the deepest pockets. We also look, is there a market need and what that target market looks like, right? Is there a need already in the industry, or is it just a slight improvement on something that currently exists, right? If there is a need in the market and it hasn't been met, that's going to potentially have a higher rate of return than something that's a mere improvement of something that's already out there being sold. And that kind of dovetails right into the next, are there current products and how many competitors are in that space, right? Is it an area where, there may be a lot of products being sold, but they're only coming from 2 companies, and we can allow another company to enter that market? Or is it one where there's 100 different companies selling into the market, and we never may be able to break into that market based on price or other factors? And then what are the barriers to entry into the market, right? How much resources would have to be expended to produce a device that was patented? Are we going to have to find an industry partner that already has manufacturing capabilities similar to the device that is novel? What kind of scale up is there from your lab to the market itself? And then just generally for any product, is it better, faster, or cheaper than what's currently out there? If the answer to all those is no, then it's going to be lower on our scale when weighted against the cost of patent protection or any other type of protection. So if we decide to move forward and file a patent, there's typically 2 paths that we take here in OTC. So the first would be a U.S. provisional application, and then typically we go the upper route, which is to file a U.S. non-provisional application, which is the full-blown application. That initial provisional application is more like flag in the ground, and I mentioned before you have a 12-month window in which to file that. Then it would get prosecuted at the USPTO, and then we could end up with a patent or not. The other route is typically reserved for applications that, one, there's already an interest from an outside partner that may be willing to put up money for the prosecution of the patents, or if that, cost benefit analysis weighs heavily in filing in multiple countries, potentially. Then if that's the case, we go U.S. provisional application, and then within 12 months move into what's known as a PCT application, or a patent cooperation treaty application. And then that gives us an additional 18 months to go into the U.S. non-provisional application and to any foreign patent applications that we would desire to go in. That gives the innovators a lot of time to do additional research, get additional funding. It gives us more time to market, and allows us to file in a number of different foreign jurisdictions, which may be advantageous to potential industry partners. But at the end of the day, how long does all this take? So as I mentioned before, patent lasts for 20 years. So that 20 years does not start once it's issued, it starts once it's filed. It even gets more complicated than that, that essentially it's the earliest priority that isn't a provisional patent that the patent claims priority to. But for right now, we'll just say we filed provisional and then went U.S. utility or PCT. So we file that provisional. And then we typically have a year in which, we have that 12-month window in which to file either a US utility or a PCT filing. And then if we go the PCT route, it's another year and a half before we have to file foreign applications and likely then go into the US as well. And once we make that either US filing or the national stage filings off of that PCT, the prosecution itself typically lasts for 2 to 3 years. So as you can already see, we've already killed 5 years of that 20-year lifespan of the patent. So your patent's only going to last likely for another 15 years if it's issued. But these wait times assume average wait times. So if your innovation is in a crowded area where a lot of applications are being received, or it is harder science, it may take longer. I've seen prosecutions last for 7 years, 7, 8 years before. So by then you're looking at coming out and only having 10 years of patent life left. And this is assuming we don't have to restart. I mentioned before that the average office action that a innovation will receive is around 2.7 to 2.8. So once you receive 2, if you still haven't gotten allowance, you can start the prosecution over again, which is how you get up to those numbers. So that's an additional fee. And you start the prosecution over again, that could then add another year, 2 years onto the process. So that means we have a lot of these patent decision points that we have to look at the cost benefit at each of these points, and we discuss them internally and out with our innovators. So one is that initial filing, which is the provisional filing. We also have to make this determination when we convert either to US only or PCT. So after that 12-month initial window. Then once we have filed, we have at each office action, we have to make the determination, can we overcome the prior art the examiner has cited against us? And if so, what is the cost going to be associated with that? And are now we kind of changing the scales of the cost benefit analysis? Then if we come to the end of prosecution and still haven't received an allowance, we're kind of presented with, do we RCE, which is essentially starting the prosecution over again? Do we appeal that rejection to a special board at the patent office, or do we just allow the patent application to go abandoned? But even if we're issued, there's still the question of, has the technology changed? So in that 5-year span, has the technology remained stagnant, or have additional innovations been added to it? And then in that case, we have to decide, do we want to file an additional continuation or continuation in part application that kind of links these two patents together? And then after that, even after a patent is issued, we have the maintenance fees decision. So at each maintenance fee interval, we have to look and say, are we getting interest from industry? And if we aren't, is it still justified to maintain this patent by paying the maintenance fees? Or should we just cut and run at this point to save money? So, and those are just some related to the patents themselves. So talked about patents extensively and kind of its decision points, its timelines and things like that. Copyright, a little bit different. Not a little bit, a lot different. So really no timeline, because a copyright is created immediately when that expression is fixed. So if you were taking notes during this, or if you have developed a protocol and put it into some kind of fixed form, you have created a copyright. So the only decision point we really have with copyrights is whether to register that copyright with the Copyright Office or not. And typically we do not. One, because protocols have a way of changing continuously. If it's software, that software is also updated on a regular basis, typically. And the only real advantage that registration provides is the ability to bring a lawsuit, which the University of Kentucky is really not in the habit of doing. So if one comes up that we would need to, we can always go in and file that copyright at the Copyright Office. There isn't that 12-month window that you typically have with patents. You can go in and register that copyright at any point. But just because we're not registering doesn't mean you shouldn't add a copyright notice to the material. So a copyright notice should be added. And typically it's the format that you see below, which is copyright and then the year that copyright was created, and then University of Kentucky. So that year may be a span of multiple years. If it was started in 2020 and finished up in 2022, it would be 2020-2022. You can add the little copyright symbol that everyone's familiar with before that, but those typically denote registered copyrights and not just copyrights that immediately attach when that idea is put into a fixed expression. So copyrights are quite a bit different. And there's not this limitation of, publication versus filing in the patent office. With a copyright, you can go back and file at any point. That's what gives you the right to sue, but typically we don't, as I mentioned, we don't register those. But that is the end of the presentation.
Thank you so much, Matt, for all that wonderful information. Remind everyone, if you have questions, please put those in chat and we'll get those asked and answered. And Matt, I do have some questions. The first question is, what if I've already published and haven't disclosed?
I guess it would depend on where the innovation sits, right? If it's something that we would want to file a patent on, still want it into our office, but depending on the timing, some patent rights have been lost. If it's still within the first 12 months after that publication, we could still possibly have US patent rights, but those foreign rights would already be extinguished. If it rests in copyright, then there's really not a whole lot of problem, because copyrights can, they are meant to be published. You essentially don't have a copyright until you put something down into writing and show it to people. So not really an issue there. So if it's, trade secret, which we don't have, it would be immediately dead. And trademark, I don't think would apply.
Thank you. Can you explain the difference between a provisional and a non-provisional application?
Yeah, so a provisional application is a more kind of truncated application. It's more of, think of it as a flag in the ground that I was here first type of filing. So we want to fully describe the invention as best we can, but it doesn't have the claim set. So in any patent, if anyone has ever seen it, you'll see a description of the invention, and at the end, there'll be a section that says what is claimed is. And that is essentially the fence that the patent attorneys are building around the invention, right? Where can you exclude others? Where are the limitations of that? And that's what a provisional application does not have. A provisional application will not be examined. There is no prosecution of a provisional. Like I said, it's essentially that, kind of notice that you were there first. It never becomes public unless we convert it to a non-provisional. But the non-provisional is typically what people think of as full patent applications. So a full description of the invention, a claim set that will be examined by an examiner and has the potential to become an issued patent.
Thank you. Are there any special requirements for IT products, i.e. Python code, numerical visualization, mobile applications, etc., when applying for protection?
So it depends, right? So whenever you're looking at computer languages and drafting things, typically those will sit within copyright. You can still get patents on computer systems and software, But the standard is much higher now. Essentially, that software has to change the way the hardware behaves. There has to be some transformative nature with that software. So most of these are in copyright. And the one thing we always have to be careful is a lot of times people now are using, kind of open source code that's out there, or code that's accessible if you only say you use it for a certain thing, whether that's research or non-commercial use, something like that. We just have to be careful if any of that made it into the software itself to know what we can and can't do. Because if some of that is in there that had a clause that said you can use this for non-commercial uses, we can't license that out and try to recoup some of the costs associated with that, or bring anything into the university. So you just have to be careful and know where the code is coming from. If it's drafted completely in-house, then of course there's no issue with that, but that rests mainly in copyright. So any resulting program, I would want to see a copyright notice on. So if there was a graphical interface for it, there should be a notice on there. In addition, if you can sprinkle a copyright notice throughout the code, so that if anyone actually got a hold of the source code and printed some of it out, that they would see, that copyright, whatever year, University of Kentucky, kind of sprinkled throughout the code.
Thanks, Matt. We have a couple more questions on the copyright front.
Mhm.
If I have foreign colleagues who participated in my writable material, should I receive their agreement to register the copyright here?
I guess, so if there's foreign colleagues that were participating in it, what we need to know is what institution those foreign colleagues are working for, right? Because typically what happens in any type of collaboration, whether it's copyright or patents, our office needs to communicate essentially with our sister office at those other institutions. So we typically, whenever this happens, we typically enter into what's known as an interinstitutional agreement. And we kind of lay that out, right? Who is going to file for any type of IP protection? Who's going to market it? Because what we don't want to have happen is two institutions kind of working against themselves. So anytime that there's collaborators, regardless if they're foreign or not, our office needs to know about it. We need to get in contact with the, like I said, our sister agency within that institution, and we'll work out how best to proceed.
Yeah. And the other question on the copyright is, can you register a copyright for a mathematical formula that has been discovered?
I mean, all right, so maybe, but you can't protect the mathematical formula, right? A mathematical formula is kind of the idea behind it. But now if I write the mathematical formula in special font and different colors and add an artistic element to that, I could protect the expression of that mathematical formula, not the formula itself, right? And the example I always give is maps, right? Just because if I draw a map of Kentucky with cities labeled and things like that and county lines, doesn't mean that you also can't draft a map of Kentucky with those county lines and city names, because those are facts. You cannot protect facts with a copyright. Now, could I still get a copyright on it? Yes, based on the colors I use for my lines, the line weights that I use, the fonts that I use to denote the cities. And you could do the same thing, but it wouldn't stop each other from being able to make that, or even stop someone else from doing that. So with respect to the mathematical formula, you could get a copyright, but it wouldn't be for what you think it is. It wouldn't cover the formula. It would just protect the way that you wrote the formula down in whatever art, art expression way that you did.
Thank you, Matt. And one last question. What should someone do if they want to talk about their innovation before they actually disclose it to the office?
Get a hold of me. So reach out to me either by phone or contact OTC and they at the email address you see, and they will send it over to me. So I have these meetings all the time, right? We talk about, where the invention currently is there enough to disclose? And if not, what other, what additional information or test data do they need? So I'm, trying to make myself as available as possible to have those type of discussions.
Thank you so much, Matt. Want to thank everyone for being here for this webinar and ask you to save the date for our March Office of Technology Commercialization webinar. That'll be March the 16th at noon. And it will be a panel of venture builders, and we will be sending out that information along with the recording of this video. And we hope you have a great day, and we'll see you next month. Thank you.